Okay, so we're going to get started with our final panel. This panel is springing off from a great paper written by Lincoln Davies and Amy Wildermuth on ghost rules, and so we're going to begin with Professor Davies.
Good afternoon, everyone. It's always the coveted spot to be right after lunch. Although I'm used to it because I teach administrative law right after lunch, and the students are just beyond enthusiastic, as you can imagine. So our paper tries to shine a light on, I think, an area of law and regulatory influence that, for those of us that think about the administrative state, for those of us who practice in law and deal with agencies on a regular basis, I think in some ways is sort of a fairly obvious kind of effect and impact that agencies can have. But at the same time, it's not one that scholarship focuses on that often. And so part of our point is to try to illuminate that area and to point out that this is something that agencies do. And the something that they do is the agencies act in a way that has sort of latent effect on the public, on regulated entities all the time. In other words, they use non-formal, and I don't mean formal and informal in the APA sense, but sort of non-formal action to try to sway the public, to try to sway how the economy operates, how people behave, what entities do. And they do this in a lot of ways, of course, and you can come up with examples off the top of your head. And so what we try to do is we try to situate a very specific kind of agency action that has this kind of latent effect that goes unchecked by the other branches of government, in large part, at least for some time, what we call ghost rules in a larger universe of other ways in which agencies might try to influence behavior. So you can think about calling up an agency and getting advice. That's one way they might try to influence you. Some of the things they do are well known in administrative law, such as guidance documents or interpretive rules. Those are ways they obviously try to influence the public. What we're focusing on are rules where the agency has either clearly overstepped their bounds, the scope of the law that they have, their enabling act, or where they're really pushing the limits of doing so, and there's a colorable argument that what they have done is extend the scope of their authority beyond what Congress actually gave them. And it's nice to sort of follow the Clean Power Plan panel because that's a very good, recent, prominent example of a way in which arguably the agency may have done this, right? And so the point that we're trying to draw is that when an agency acts in this way, through rulemaking or in any other regard, to try to extend the scope of their power, what they do is create this period where they can influence the economy. So if you look at the Clean Power Plan briefs, for instance, they talk about the ones challenging the Clean Power Plan. They talk about specifically this idea that the EPA is trying to transform the economy, and they do it, of course, in a way that's laden with advocacy and trying to make that specific point. And the point they're trying to make, of course, is that the agency's doing something that's very transformative of an entire industry on a very thin reed. And that's the kind of problem, whether you agree or disagree that 111D is enough for the EPA to be acting in the Clean Power Plan realm. That's the kind of problem that we're trying to shine a light on. And we're trying to talk about the impacts of it. And then we're also going to talk about why agencies do that, because there are a lot of different reasons you can come up with for agencies in terms of the kind of strategic thinking that might go behind the scenes of why they might adopt such rules, even though they know they'll probably be challenged in court, and even if they're not challenged in court, obviously now they've created this effect that they weren't given the authority to do. And if they are challenged in court, even if they know they might be turned down, eventually they know there's this sort of lag time in which they can have this massive impact on society. And in some ways, as the Clean Power Plan briefing makes clear, they also recognize that sometimes they do it specifically because of that. Because if they create enough regulatory inertia as they move forward, they've now basically won the game before the court challenge can even happen. Now, of course, in the Clean Power Plan litigation, they got a stay from the Supreme Court. I think a fair number of people were very surprised about that. And so that's the last part of the papers we're starting to look at. Is that an adequate mechanism? How have courts treated stays? And for that part, I'll turn the microphone over to my esteemed colleague, Amy Wildermuth.
Okay, so thank you, Lincoln, and thank you so much for having us here. This is a great opportunity, and we're excited about this paper. It's been a difficult paper. I've done papers before where we've collected data sets, and I have to say that collecting data sets on preliminary injunctions for legislative rules is one of the more interesting areas that I have gotten into. And I say this because I have never encountered a data set where all of the sort of legal analysis looks so very, very different, even within the same district court boundaries, right? Even within the same court of appeals. You might even offer here to say that when you look at how people work through preliminary injunctions, it's as if it's their first time coming back to it. And sometimes I see wild inconsistencies between an opinion, written by a judge 2 years ago and then one we might see today. So it's been, this one has been a much more interesting journey than I anticipated. I thought we would see something that was a little easier to follow, and for that reason the data set has taken quite a while for us to get through. Now that said, actually that inconsistency has given us some reason to believe that maybe there could be a better way that we could approach the preliminary injunction test when you think about rules that are coming out from administrative agencies. So if one of the concerns that we have is about investments that and major investments that regulated entities would make before we could get through the entire legal challenge, as Lincoln was saying, maybe there's something we can do in that preliminary injunction test. And I'm sure everybody remembers that preliminary injunction test. I know in Civ Pro, I teach it as a very easy 4-pronged test. I can't believe it's this hard, right? But basically, you look through things and you see that there's the merits test, and then you have sort of the relative harms, right, and the public interest. What we find on the merits is that you either have somebody, you will have a court say, a very brief little something about the merits. There's a substantial question here, right? Just enough to satisfy that it wouldn't be something like a 12b6 motion where it's just frivolous. And then they will go into the relative harms. On the flip side of that, we have courts engaging in very extensive analysis of the merits of the case. Remember, these are all preliminary. And many, many of them, because of the extensive analysis, just go on to decide the case. It's quite an interesting phenomenon. So is there something that could be done there? Is there something that could be done in the sort of relative harms area? There's lots of academic literature out there on preliminary injunctions and what might be done. But we've settled in a different place, and so now I'll get to the punchline. That's the most exciting part. And that is that we think maybe the best way to do this is to think about when those major investments need to be made under one of these rules, right? Not any investment, I mean a major investment. And let's see when the timing for that plays out. And if we have to make a major investment, we've sort of marked it at 2 years, because 2 years is about as much time, hopefully, that it would take to get through legal challenges. Obviously, it could be extended, but we're using 2 years as a sort of marker. If we have no major investment within those 2 years, it would seem that you would not need to have an injunction or a stay issued. If instead a major investment needs to be made earlier, we would presume that we would, in fact, enjoin the rule so that it could get through the legal challenge and get through the whole process, with some exception for health and safety, right? Always preserving an exception for immediate threats to safety and to the health of the public. So that's where we are. Okay.
You're so brief. Okay, I think Clyde, you're going
You want to go now?
Yeah, sure.
This is a really interesting paper. It's on ghost rules, but you go through a whole haunted house. The bureaucracy's a haunted house. You've got the animated spirits. The only one you left out is poltergeist, I think. But what this is getting at is something really important. You have the laws Congress makes. There were 224 last year. You have the regulations that agencies produce each year. There were 3,410 last year. So you've got a multiple of 30 in terms of just what agencies are putting out on the books. But beyond that, you have all of these other guidances, circular, directive, administrative notice, petition, letter, memoranda. One time I made a word cloud out of this stuff at CEI. And what's valuable about your paper is putting together a taxonomy of when these kinds of guidances are coercive and when they're suggestive, and that's suggestive in parentheses, I guess. And when they apply broadly and when they apply to in certain areas. So it's extremely important. It's really important that this law school and that scholars are paying attention to this question. In my case, I came about this looking at this issue in putting together a report. I realized, no two people see the same rainbow. We're all looking through different raindrops, and I heard cost benefit brought up earlier today. No two people see the same costs and benefits of regulations, and it's one of the issues that we run into. And this kind of fight is a deep fight. It's like the fiscal battle also in terms of debt ceilings and when we raise taxes, government's role in the economy, separation of powers, the role of the executive overreach, the whole relation of the individual to the state. So when I approach regulatory issues like they've addressed in this paper, and I can tell you this paper I think is going to help a lot in terms of creating better inventories and tracking of this kind of off-budget regulating. But my own bias in this is, I want to see I like to work at CEI advancing institutions of liberty, and part of those institutions of liberty are not building big new regulatory apparatus to manage the frontier economy. Now, this summer, I was invited to participate in a Cato Institute, Cato Unbound back and forth online debate on the administrative state. Now, I'm not a lawyer, but what struck me at that, and what always strikes me at events like this, is the degree to which Congress is seen by some as optional. And the agencies are experts, so the Congress is optional. And I have to say, I do not regard agencies as experts, and that's something we can get at a little bit later. But it leaves us debating deference questions and and things of that sort. So we're preoccupied with questions of, well, can this agency interpret a statute the way it wants to, or can this agency interpret a prior noticed and commented upon regulation the way it wants? Can an agency reinterpret a prior interpretation of a guidance document without going through a notice and comment period, and all these sorts of things? That all is, you need to do it, but it all worries me a little bit, because like a net benefit debate, when you're fighting a bureaucracy about an agency, they always come up with net benefits for regulations. And if you're in that sandbox, you have issues. And here I'll get at why, and this gets at the inventory and the kinds of haunted house items that are so important in this paper. The $19 trillion debt aside, I think that when we're missing the regulatory state and the regulatory bureaucracy and the ghost rules and the regulatory dark matter, as I call it, I think you're missing the biggest part of government's impact in the economy, and I think we have to pay a lot of attention to it. There are a few things we do know, like just this morning, the Federal Register hit 64,048 pages. That's a record pace. Last year was over 80,000. We've had 3 over 80,000 just in the last few years. 3,410 regulations. Estimates of regulatory costs. Mercatus has one of $4 trillion a year in terms of losses into the economy from lax investment. If you were to have frozen regulation at the 1948 level. And going forward, my own placeholder for it that I call the Kostberg is 1.9 trillion, using a lot of government studies on regulatory costs. You can compare those to the spending on the budget. You can compare it to other countries' GDPs and so forth. But those are at least things we can look at. They're a little bit tangible. But the problem with ghost rules and these sorts of things is, this stuff is very, very hard to track, and one of the reasons it's so hard to track is because even for the ordinary notice and comment rulemakings, we fall down in terms of guidance over them. The OMB's new cost and benefit report is still late. Last year it came out in October. It was the latest one there had ever been. We're almost at October. This is the report that gives you the costs and benefits of regulations, but the problem with it is OMB, as the rules are flying through, looks at about 600 of them. And the last time the cost-benefit report came out, they looked at 600 rules, but there are about 30 that have a cost analysis, but there are only 14 that have a cost-benefit analysis. So there really isn't any cost-benefit. So that's one of the issues that is ominous when you think about the situation with ghost rules and so forth that come later, that trickle out of the regulatory process. Beyond that, there are costs of benefits. When we have these debates about guidance and regulation, everybody knows the incentive issues. You always hear at George Mason that don't require airbags, require a 6-inch dagger in the steering column, and people drive more safely and things like that. But it's not just the incentive issues. It's the notion that the things that we regulate, the things that we want to regulate, privacy, cybersecurity, clean environment. Those are forms of wealth. You also have to have market pressures to regulate those as well, not just an administrative state to regulate and make those things advance. So those are a couple of problems with the regulatory state, but as you get down into it, you realize that we don't even have, there was just a GAO report that came out of ordinary regulations. There's a lack of notice and comment for 44% of the regulations that go through. They didn't include a notice of proposed rulemaking, and it was a third of that for major rules. So that's kind of poor regulatory processes, and then the regulatory dark matter or the off-budget regulation makes things even worse. And what's occurred lately is that there was a hearing in the Senate last year in which Senator Langford and Senator Heitkamp were asking the Department of Education and the Department of Labor, well, when you sit down and you start to issue a rule or a piece of guidance, what do you do? How do you decide whether to issue a rule or to just issue a guidance? And they couldn't answer the question. So it's a real problem.
Okay.
How much time do I have?
No, well, this is great, and then we can take up more issues in the
Okay, because I can give you some examples or something if you
want to give a few examples, sure. Go ahead.
Well, just look in terms of looking at the amount of guidance that's out there. There were 580 pieces of significant guidance that's out there now in play, but thousands and thousands of non-significant or secondary guidance that's out there in play. And some recent ones have included the Labor Department's independent contractors rule is one of the most important ones, and the franchising rules and so forth. But we'll cover some of those in the Q&A.
Okay, thank you. Professor Pierce? Okay.
So there's a lot of topics out there on the table already. let me take a crack at a couple of them. Let me start with stays. I really agree with Amy and Lincoln that I think there's a good chance that we're going to see more and more of the major regulatory disputes resolved completely at the stay point in the proceeding, and I don't like that result. I don't think their solution works worth a darn, because I think the lead time necessary to comply with rules is really, really long, a whole lot longer than most people realize. And let me just use the Mercury case, which I think was the reason we got the 5-4 stay of the Clean Power Plan from the Supreme Court, just to illustrate that. So the Mercury case, there's a rule that's usual, big rule, controversial, costly, benefits, it depends on how you calculate them. They're either massive or small. It goes to the D.C. Circuit, request for stay denied. Then it goes to the Supreme Court. The Supreme Court, 5-4, says that the rule is invalid. And then the spokesperson for the EPA, wise politician that she was, says, oh, we just wanted to announce today that that Supreme Court opinion has no effect whatsoever because we accomplished everything already, because everybody already complied. I mean, I understand that the Chief Justice went through the roof of his office when he read that, and as he did in every brief that came in asking to grant the motion for stay of the Clean Power Plan. If that's the situation, then the Supreme Court's going to say, all right, we're going to start playing this game a different way. We're going to start staying rules because it appears that our decisions on the merits are irrelevant. So I went to the proceeding on remand in the D.C. Circuit. I went to the oral argument, and it was fascinating. So all the owners of coal-fired plants who had been on the side of the states that were trying to get the Supreme Court to hold, and were successful and get the Supreme Court to hold that the rule was invalid, switched sides and said, we are absolutely opposed to your vacating this rule. Why? Because they had, as soon as the rule was issued, gone to their state regulators and said, we have been told we must do X. It will cost us a big pot of money. Will you please authorize us to recover the pot of money that we have been mandated to spend? We got favorable answers from them. If you pull the rug out from under us now by vacating this rule, then a lot of them are going to turn around and say, we're not going to let you recover this from the consumers. You got to eat it, because this is no longer something you're required to do. You just decided to go off on a frolic of your own and spend all of this money. So I think there's going to be more and more cases like this, and it's not limited just to these big EPA rules. I would note that the big immigration dispute that got the decision of the Fifth Circuit upholding a stay, and then the 4-4 upheld by an equally divided. That's all about the stay. Will we ever get to the merits? I doubt it. I think it'll be resolved completely at the stay level. The transgender bathroom rule is all about stay. I think we're going to see more and more cases resolved at the stay level. I think the lead time to comply with rules is such that it's very, very difficult to do this, to get the merits resolved before people have to act one way or the other. And so this is likely to happen more and more. I don't have a solution to it. I would tell you that if you want to see what it's going to look like, look at the FTC merger world. The Federal Trade Commission, when the Federal Trade Commission asserts jurisdiction over a merger, there's never a decision on the merits. The battle is all about the stays, because never can you get a decision on the merits before the deal collapses. So everything in that context for decades has taken place in the context of stays. We may be entering that kind of world in the case of a lot of regulatory actions, and I don't have a solution to it. Guidance documents. Just a couple of points. So, one that's perhaps the most important. It's important not to over-deter agencies from issuing guidance documents. Lawyers have a really bizarre, distorted perspective on guidance documents. They know all about the 1% that their clients hate. They don't know a damn thing about the 99% that their clients begged for in order to deal with the worst problem out there in operating any business, uncertainty. And in many cases, they say, look, we can go this way, we can go that way. Tell us which one is lawful. And they beg for this stuff, and then every once in a while they get one that wants something that says, oh, damn, that's a problem, let's take it to the lawyers, and then the lawyers think, oh, all these guidance things are horrible. Okay, that's not the way the world works. Most of the guidance documents are nothing but beneficial, so don't over-deter them. Now, there's not as much abuse out there, potential abuse, as most people think. There's this hour doctrine that you may or may not have heard of this morning, but it's a doctrine that some people think says, well, an agency can do any damn thing it wants in interpreting its own rules. And the Solicitor General's office believed that to be the case, and for that reason didn't want to file a petition for cert in the mortgage bankers case, and I had to stick their nose into reality and say, no, you lose 25% of these damn cases now. This is not an automatic win for you. And then when you look at what the Supreme Court did in 2012, after I did the study that concluded the government loses 25% of these cases, it issued an opinion that makes it much harder for agencies, increases the hurdles for agencies. So now you're talking about a doctrine that's no more deferential than any of the others out there, and that has lots and lots of hooks attached to it. And I think you're going to see the Supreme Court using those hooks, and also you're going to see them using things like the major question doctrine more and more in contexts in which they traditionally have deferred to agencies, because I think what all the justices are concerned about now is the combination of deference doctrines and political polarity. And when they look at what has happened for 30 years in the context of the wage and hours law, if anybody's ever followed that, there's a wonderful piece done by a scholar at University of Florida a couple of years ago, where what she shows is every time the White House changes hands, all the rules change hands. And under Democrats, everybody gets overtime. Under Republicans, nobody gets overtime. And it's just a complete flip-flop. And in that context, the Supreme Court, as the last opinion in the term last year, issued an opinion in a case called Encino Motors, in which it made it real clear, you're going to have reasons. And I think the reason that the court issued that is because it's increasingly concerned that if you get a Republican, all the law goes this way under a deference doctrine. If you get a Democrat, it all flips-flops. And we just can't tolerate that. We might be able to tolerate it with the Wage and Hours Act, but we sure as hell can't tolerate it with things like the Affordable Care Act was entirely lawful under the Obama administration and then became unlawful under the Trump administration and then became lawful again under the that's just nonsense. And so they're concerned about that potential effect of the deference doctrine in a period of political polarity, which is likely to last forever. And so they're cutting back on deference and adding more qualifications to what it takes for an agency to be able to pass muster in court with one of these actions. One final point. Now, Wayne and I do battle all the time before congressional committees on things like regulatory budgeting and There's the massive cost part, and as Wayne well knows, there's the massive net benefit estimates that come from the agency we both love, OIRA, where OIRA says, yeah, but the benefits are a whole lot higher than the costs. Enough about that. We'll continue our debate at the next congressional hearing.
Okay, and then Jeff Clark?
Thanks, Naomi. Well, it's quite a tall order to follow the great Professor Pierce, as much as I disagree with him. But let me give that a shot, maybe. So I think this is implicit in the paper, but I think that the spotting of the problem of ghost rules and its various spectral and undead cousins is very important that the paper's done, and it's very consistent with the constitutional structure. Right, we want agencies, I think, to be inferior actors and not superior actors, and I think that's one of the background premises of the paper. At this point, we've really gotten, I think, to a stage of development where the agencies aren't even acting as a junior varsity Congress. It's more like they're a wayward football team. They're calling their own plays, and then Congress is on the sidelines sort of scratching its head confused, not even about the fact that they called a play that the quarterback's not running, but that there are plays being called that aren't even in the book. I think that's where we stand now. And I think in contrast to where Dick is, of not wanting to over-deter with things like guidance documents, I think, you'll forgive me for a religious analogy, but Paul had counseled Christians, right, that they're supposed to work out their salvation in fear and trembling. I think we want agencies to be working out whether what they're doing is lawful or not in fear and trembling. And I think we have long passed that stage. We're now at a stage where they work out what they want to do based on audacity and salivating about what the prospects are of what they could achieve, and I think that's constitutionally upside down. I think one of the main ways in which I hear this being expressed when I speak to people who defend this kind of approach is that Congress is inactive, and therefore we in the agencies must step in to provide the answers that the world needs. And I think that's also constitutionally upside down as well. If Congress is inactive, that means that the democratic will is that there should not be movement on some of these issues, and that if agencies are trying to work movement on those issues, they're acting contrary not just to the congressional will, but that what it reflects in a Republican democracy, which is what the will of the people is. And so, I think that I hear, Dick, about some of the opportunism points about how things change when administrations change, but I think it's time to try to return to something closer to the constitutional structure and to recognize that we don't want executive branch agencies innovating that much, especially because, half the time you're going to find that the people the people you disagree with politically are the ones doing the innovating, and it would be better to have a principled approach. Turning to the paper, I think Amy and Lincoln know that I'm a big fan of it, especially the taxonomy part, and I think that's really a very nice contribution. It lets them do all sorts of fun things with the analogies to ghosts and undead. But I think the paper has two halves to it, right? It has the half about the taxonomy, and it has the half about the stay approach. And I'm not sure that they really fit together harmoniously, in that the stay part just talks about one particular problem, ghost rules, and has one remedy for that. I'd urge them to look at one of the things Congress was considering, which is the Review Act of 2015, HR 3438, which would put in place an automatic stay essentially for any rule that would cost $1 billion or more. Those kinds of things Congress is increasingly toying with. I also think that it's an important factor to look, as Dick was saying, at the lead time agencies need. And indeed, several important environmental statutes have specific lead time provisions in them, and yet they are rarely, if ever, considered in the course of stay analysis. So for instance, if you have a statute that says a particular industry is supposed to get 3 or 4 years lead time, well, if the litigation is going to take 1 to 2 years, you're basically eating into what Congress has recognized as your lead time. You really should be able to actually not start complying until after the kind of cloud of uncertainty has settled over whether those regulations are lawful or not. I also think for that reason, right, that the second half of the paper would be better if it were broadened so that the remedies match the taxonomy. And just as one example for that lets me do a little bit of analogy mongering of my own, there's a discussion at one point of zombie rules, and there isn't much of a sort of discussion of the solution for that. But basically, the issue there for the zombie rules is, is that it raises important questions of enforcement discretion. It raises important questions of, is an agency really entirely ignoring the law if it's not enforcing a doctrine that's on the books? And then also the question of guidance documents, which in that particular instance, right, the big fight is what is a legislative rule and what is a non-legislative rule, which is about as clear as mud in the current doctrine. It would be great to get that cleared up, right? It reminds me of the line from the Black Sabbath song Iron Man, where like, is he live or is he dead? And as I'm trying to counsel clients about some of these guidance documents, it can be very unclear exactly what side of the line those are going to fall on. So, and then all of that leads me to ask, especially given what a big problem we have these days, which I think was the genesis of the paper with the Clean Power Plan stay, and then the history that Dick reported about, the sort of Michigan victory dance that Amy and Lincoln talk about, is, do we need a more radical remedy? And again, some more analogy mongering. Is it, if you're getting so many of these power grabs, if you're getting so many of these situations that look like they're egregious attempts to just go beyond the statute and start, having the agency make its own policy, is it time to head directly into the charnel house and start clearing out the undead and the spirits, as opposed to just waiting for them to issue forth a new apparition that you then try to bind down with some kind of silver chains or something through the stay process? That seems like not a particularly effective regulation. So I'd suggest maybe it's time to think about, especially for agencies that are issuing a lot of these ultra virus things or power grabs, is it time to storm Carfax Abbey and look for Dracula and his kin? Let me say 2 other things about it before I kind of hand things back to Naomi, our moderator. One is, I'm not sure the species analogy in the paper worked. I thought they'd done such a good job of the taxonomy of the different kinds of rulemaking creatures that starting to talk about different kinds of species, ecological species wasn't so helpful. And then in the discussion of the stay analysis, you have to talk about the Winter case because it is such an important case in terms of granting stays. But Winter wasn't a case that involved rulemaking, right? So it's peculiar in that sense to kind of start drawing conclusions about whether the status quo approach of trying to make sure that if you're going to grant some form of a stay, which is essentially equivalent to a preliminary injunction, and it's the same standard, are you going to be preserving the status quo or not? I mean, I'd submit it's not really that hard to figure that out in the rulemaking context. The status quo for a rule that has just been issued while it's being challenged is that it is disturbing the status quo. It is disturbing the pre-regulation legal order. It's changing the legal order. That's why industry, when they're challenging these, or environmental groups if they're challenging these, they're asking for some kind of preservation of a pre-legal order status quo. The Winter case is different than that, so I wouldn't draw big conclusions from it because it's a lot more debatable what the status quo is there, although I even think there it's clear. The status quo was the Navy had been doing training exercises for decades, and along came some environmental groups who sought to disturb that status quo. So, so anyway, that's where I'll wrap up. There you go. My alarm told me that was my 8-minute limit, and I'll hand back over to Naomi.
Great. Well, thank you very much. You guys were all very disciplined in your timekeeping. I appreciate that as the moderator. So, so I don't know, Amy and Lincoln, do you have any responses to some of the comments that were made? And then if other panelists also have remarks or responses?
Yeah, so I guess, I think there's potentially some merit to thinking about things more broadly. I think we will, in some degree, focus on stays in part because that's the primary mechanism that often gets used. But I take the point that there's some value to thinking about broader reforms, and the Review Act is a really good, I think, example of that kind of thing, where we might think of other similar mechanisms that deal with some of this. As the guidance documents, I guess maybe my perspective is skewed, Dick, because I spent 7 years representing industries that were regulated and know what they go through, and the kinds of things I would hear about in terms of guidance documents really were the complaints. And maybe it varies from agency to agency, but I guess I'd be interested to hear more about the instances in which you think these guidance documents come up, or specific examples that they really are beneficial, because I think that's worth fleshing out, right? I mean, we're talking about ghosts. There might be some, maybe people will disagree with me, I think there might be some friendly ghosts and some not so friendly ghosts. So I think it's, important to keep that idea in the paper in terms of, looking at things holistically. And then I'm not sure I necessarily agree with you, Dick, in terms of the question about how much lead time there is to comply. One of the things we're still working on is trying to look at data to see exactly how long industries often get to comply. And I think that might be helpful, but I would sort of side more with Jeff in terms of this idea that, usually the rules I've seen give you a certain amount of time to comply. Maybe you ask for the stay, maybe you don't, but by the time the litigation's over, either the time's up or it's about to be up. And it seems like it's usually faster rather than longer, but I'd be interested in counterexamples because it sounds like you might have some in mind. And I totally agree with the FTC merger point.
I had one related point to that, if Dick wants to take that up as well, which is, I wonder if one of the difference between friendly ghosts and the less friendly ghosts relate to the size of the regulated entity, because I think, in my discussions with people at companies, the bigger companies, they really value certainty, and they can always roll the costs of new guidance into the costs of doing business, whereas, the smaller entities are less well represented in the agencies, and for them, the costs, the certainty is maybe less important than the new costs that are imposed. So I wonder if that is something that either of you have experienced or seen.
All right, let me try to respond to some. That's a real gem, Naomi, because I'm about to say something that is really politically incorrect and unpopular. I once wrote.
That'd be a first, right?
Yeah, I once wrote an article. It's been 20 years now, but it said, "Small is not beautiful." This is something that we bought into hundreds of years ago, and we continue with small business is good, big business is bad. One thing good about a small business is it has the potential to grow into a big business. And when you look at everything we're trying to avoid with regulation, it is massively higher in small businesses than in large businesses. And there's a whole lot of economic reasons to expect that result. So what I argued was there shouldn't be exemptions like there are, the hundreds of exemptions. If you're small, you can pollute and kill your employees all you want, okay? They should not exist. And by the way, that would then have interesting effects on the rules, the generally applicable rules, because then the small businesses, now they tend to say, hell, we got ours. we don't give a damn what they do to them big guys. They would then be in the same boat, and they would be adding their bargaining power, their sources of leverage to the big firms, and you'd get fewer unreasonably generally so. But that, I mean, try and sell that to the American public. I mean, everybody believes small is good, big is bad. Well, all right, on to some of the other.
I don't think that's what I said, but it's okay.
Well, there's no question it's harder for small firms to, and they should damn well go out of business. And those kinds of functions that pose big safety hazards and create environmental hazards should be done by big firms that have the capability to have the pollution controls and the safety, health and safety controls, and not done by little bitty firms that kill lots of people and do a lot of polluting. That's my answer to that. You're right, but I would go the other way. But I'll never win that debate anyway. So some of the others, so Lincoln asked me to come up with, wow, yeah, it's about, what, 40,000 guidance documents a year issued? And there's controversy about less than 1% of them. Going through all the dogs that don't bark and trying to figure out. I mean, I draw the inference that the vast majority of those, when they're received by the operating people as opposed to the lawyers, they say, thank God, now we know we do X instead of Y. Maybe we would have preferred to do Y instead of X, but we could do either one. And man, clarity and certainty is really, really valuable. But no, I can't go through. I mean, I suppose I could take a random sample of 500 and
I'm not asking
show
you to
the
go through all
benefits,
40,000.
Yes, we are.
Overstating the question. I mean, the question is whether you knew.
I could go through. I could just take a random sample of 100, and in most cases, you're going to say, "But that doesn't do much." Well, that's the point. All it does is provide a little bit of guidance to. But okay, on to.
I think Wayne wanted to.
Other questions? Oh, yeah. Oh, my basic response to Jeff is, I mean, I agree it's important to do this in a constitutional manner, but I thought the last panel, I was amazed that they seemed to agree on something that strikes me as the answer to all of these constitutional questions. The courts need to answer the question, did Congress provide the agency the hammer it used in this case? That's hard. I mean, I know what the two big legal issues are in the CPP case. I rate them about 50-50. I could easily write an opinion defending either a yes or a no with respect to each of those. I don't have any doubt the judges in that situation are going to be influenced by their view of the policy implications of a yes or a no. And hence, I'm predicting that it's going to be resolved on straight party lines, first at the DC Circuit and then in the Supreme Court. But that only happens because we're in equipoise on that really important question of whether Congress gave EPA the hammer it's used in this situation. And as long as the courts are doing their best to draw that line, then I think we're all right in terms of keeping things within constitutional bounds.
Okay, Clyde and then.
Yeah, I think we're going to have to broaden what we think of as regulatory restrictions in an economy. There are businesses that are long-standing and industries that are long-standing that are faced with environmental regulations, for example. But a lot of industries are new, and my hope always is that most of the industries we're going to have aren't created yet, and most of the jobs aren't created yet. There was just a 624-page rule on drones that came out from the FAA a couple of months ago. Now, I took a quick look at it and scanned through it on this question of guidance, and just a quick review of it, I found at least 6 areas, and this is basically a non-existent industry yet when you're talking about public applications and deliveries and things like that. Virtually a non-existent industry. You're not talking about a power plant that's been around and also heavily regulated, by the way. They're not non-regulated firms. But this rule came out. It has at least 6 areas where the agency is promising to issue guidance in the future, and it's undetermined what it is. It's completely invisible. You don't know where it's going to be. But it mentions areas like pilot certification, airworthiness, weight, and things like that that really have to be resolved. There's no way this is what I was saying earlier about agency expertise. The agencies they don't know how that is going to work out. And I won't belabor drones. I'll come back to something even more important on it later if it works. But similarly with federal communications regulation, we have this, what is it now, 12-year battle over net neutrality, and we finally got this rule, 400-page net neutrality rule, page 80. They're not issuing guidance. They're saying if you want to invest in the future in internet infrastructure, you need to check with us first. We're going to act like the FTC or whatever on a merger or something like that. So you've got this relatively new industry that we have of growth of the internet that now has to play mother may I with the FCC. They're not waiting for guidance documents. They have to check. They have to check in. So it's not just guidance documents. It's the notices, interpretations, and circulars and bulletins and all that. However, I do agree. When I first started looking at this, it is the case that a lot of businesses seek guidance and they want it. They want that kind of certainty. And there's a lot of problems with regulatory uncertainty, but there's also a lot of problems with regulatory certainty. And that's one of the things that I think bogs us down in a lot of ways. Just another quick example of this is, we got the Dodd-Frank law, and in terms of the Consumer Financial Protection Bureau and its unfair and deceptive trade practices provisions, so we're not going to issue any regulations. We're not going to issue any guidance. You just have to check with us before you move. So when you have a situation where you have rejected the market's disciplinary function, and we're not going to debate that here today, but there are a lot of ways and a lot of forces arrayed against competitive enterprises that I think regulate them better than bureaucracies do, but we're not going to do that here. But when you reject that, I think you create real problems, and you create a situation where in energy, healthcare, now the frontier sector, driverless cars and drones, where you have to work through the government to move, and I think that's entirely inappropriate. And it's not even like this drone rule. That should have been a law from Congress. And if we have problems with small businesses polluting that way and getting it, that's a signal that you need to revisit with legislation, not with guidance and things of that sort. But my point is, you can regulate now without writing anything down. It's not just guidance documents anymore.
We'll take
So that's
Jeff's
another-
comment, and then also we'll take some questions from the audience if there are any. But go ahead, Jeff.
It's probably, I won't be too long because Amy probably wants to hop in too. But just a couple quick things in response to Dick about both the small issue and the constitutional issue. So on the small issue, I think the key point, there are two key points. One is, you get a more dynamic economy. If you look at Europe, if you look at other places where you don't have small business growth, if you shut that down, you're really closing off one of the major engines that makes America different and keeps America moving forward economically. And the other thing is that, look, and I represent mostly large businesses. The reality is that large businesses do engage in public choice style behavior that systematically disproportionately hurt small businesses, and that's a factor that has to be kept in mind. So I think that's the pitch for why small business needs some particular protection. I just worked on a case that came out from the Seventh Circuit. My work on it started maybe 2 years ago. It was a situation in which the Department of Energy forthrightly acknowledged that they were going to put many, many small businesses out of business, and their answer to the fact that Congress had called particular attention to that was, as long as we check the box and we've done some analysis and told you we agree that small businesses are going to be hurt, our job is done. Who cares? On to the next rulemaking. And constitutionally, look, I think that the test of whether one can write an opinion or not, and clearly, Dick has legal creativity. He could write lots of opinions in lots of different directions. It's troubling. That shouldn't be kind of the right constitutional approach. When I walked in the door as Deputy Assistant Attorney General at the Environment Division in 2001, I got maybe 90% of my work was defending prior rulemakings in the previous administration. And could I write briefs that defend those things? Yes, but that's not really the test. And I think that it was increasing skepticism about how deference had really gone off the rails, and courts and lawyers had become deference happy inside the agencies that was leading Justice Scalia to question Chevron at the end of his life in the mortgage bankers case, and by some reports outside of that.
Did you want to?
I just find it fascinating that all of our panels have come back to one of the central things that is really motivating so many of the things that we're talking about, and that is the congressional inactivity or Congress's retreat. We're all talking about workarounds, and admittedly, our solution, especially when we think about stays and the preliminary injunctions, this is all arising very, very recently. So one other feature of this lovely data set that we have is that you don't see all that many cases before 2000. You start seeing a little bit of a trickle, and now you see far more cases in which people are asking for preliminary injunctions. I cannot imagine it is the case that we weren't teaching preliminary injunctions before 2000. I'm pretty sure that's not true. So it's an interesting phenomenon, and I certainly think that root cause of so much of what we're talking about is the problem, right? And maybe what we should do is think about how that problem should be solved. But as Dick said, I don't know if there's any solution to it.
Just quickly on what you raised about Congress. When I got interested in this issue a couple of years ago, I started wondering. Usually when you get any kind of regulatory reform or liberalization, it's a bipartisan notion. That happened in the late 70s and 80s, and it happened with, say, unfunded mandates reform. It is now back, still an issue again with the National Conference of State Legislatures. But there are a couple of reg reform bills that are bipartisan in nature. Senator Warner had proposed the idea of one in, one out. Loosely talking about burdens of rules. Just a way of thinking about what's on the books and what should come out. There's a version of that Senator Sullivan had put out that includes guidance documents. So there's a little bit more attention to the guidance side of it as opposed to just the regulations as well. And in fact, when Dr. Pierce and I testified on regulatory budgeting, I'd looked at Senator Lee's bill. It wasn't exactly the topic of that particular hearing, but Senator Lee's bill, in fact, had encompassed guidance documents to some limited extent. What I would hope is that if this kind of an effort of trying to catalog them, which is what I'm trying to do in the Reg Dark Matter paper and what y'all are doing with the taxonomy, and I hope you do more case studies looking at guidances and circulars and things like that. But I would hope that Congress does get engaged in some way. We're in an election period, and after that you don't know what happens. You have a new OMB and OIRA looking at regulations, and occasionally they'll look at a piece of guidance. And it might be something that just gets amplified, and then you determine for sure how much is and is not a problem.
Do you have any questions, James?
Yeah. So one question.
You're gonna just wait for the mic, sorry.
Oh, of course.
Thanks.
No problem. So I have one question, mostly for the authors, and then one question maybe more for the panel. The question for the authors is, taking on board Dick's point that OIRA is going to have, with almost all of these rules, said that the benefits far exceed the costs of the rule. In how many instances, and you guys may know from the data set, would your rule have provided any additional hope of a stay? Because I imagine the typical situation is the court would be looking at something where even under your rule, as long as the agency can make a strong showing of harm to public health and the environment, they're still not going to get a stay. And I assume most of the rules that we're most worried about the agency going out on a limb, they're going to have strong showing of some kind of benefit that starting the regulation as soon as possible is going to provide.
Sorry.
So that was the start. So that's the start of the question for you all, and then maybe a broader question. What about the idea of having some kind of stay, like you have with the proposed Review Act for major ones, but that requires some skin in the game from industry with some kind of bond that they forfeit if they don't win the ultimate, if they ultimately don't win on the merits?
So if I could start with just the question of sort of the mechanics of preliminary injunction. One thing that we would say here is that when you think about the preliminary injunction, you're supposed to be balancing the harms during the litigation, right? So it's not the overall cost-benefit analysis, like over time, we're gonna save, you know, all of these lives and that's worth this much. But it's within this 2-year period, what is it that we're gonna do? Or the 3-year period, or whatever we think it is, that it will take to litigate. So I think it's a different analysis in terms of how you get to the relative harms. And I think what we were shooting for here is to think about during that time period, again, because you see sort of courts that are all over the place, and even the same judge all over the place in opinions. How can you make it so that this is sort of a more straightforward exercise? Because right now it has, shall I dare to say it, an element of randomness, right? It really is coming out about 50-50, and I can't really tell you why. And so
Because how many sides a coin has.
there we go, right? Yeah, so I think that makes, it certainly makes me nervous that we don't have more rigor in the analysis. And I think what we were shooting for, again, is just to get to a place where we have these presumptions so that it is more understandable if you're sitting in industry. Okay, are we going to actually be able to test this rule, or do we just have to accept it? And whether it's valid or not, we're going to have to comply. I mean, I think that's really the concern. The question, and then I don't know if I should take the question about whether we should have a bond.
So, James, this kind of relates a little bit to our conversation last night about how these challenges are brought, right? So I would say, you know, as I thought you were kind of recognizing in our, so to share the dinner conversation involved the collective action problems that trade associations face in challenging agency action. So they have a, you know, I think what is widely understood as a big collective action problem, and we're going to add a bond requirement to that. I mean, that just seems to be, you know, like if it was
They're getting something very good, to be fair, right? They're getting a stay, like a stay that they normally wouldn't get. And you know, and if you want to tell me that bond is, you know, $10,000, that, you know, that's fine. But in theory, what do you think of this?
Yeah, I mean, I think that it just makes it harder to bring challenges, and I think, you know, as at the earlier stage with Lincoln and Amy, I talked about, I have never encountered a client who's come to me and said, you know, this rule we regard as fully lawful, we just don't like it, so we're going to send you off to challenge it, to just like create and go seek a stay that, you know, you may have a low percent, but if you get it, great, and we'll be very happy with the stay. I don't think that ever happens. Whereas I do think, you know, we see situations in which agencies are doing things that are seriously ultra virus, and then sometimes they roll the dice and they win, and sometimes they don't. I would think adding the bonding requirement is like adding insult to injury, would be my reaction.
And I just want to say that I think Lincoln and I have a little different view, and that is that we would say that regulated entities are not going after things that they really don't think are unlawful, and I don't think agencies are promulgating things that they think are unlawful. I think they think they can defend them. So I think if you start from that place, this still is a sensible resolution.
I think Brian has a question behind you if you want to just hand it up. Thanks.
I guess it's a related question. I haven't looked at the Review Act, but the short description I read of it, it seemed to me it would encourage meritless litigation that people would file just to take a rule hostage. If the stay is granted automatically and it's costless to get it, you're then in a bargaining position with the agency, and you know, for dilatory reasons or bargaining reasons, you may see a lot more litigation. I can't imagine the courts would welcome that. So I don't know if a bond is the solution,
But
it did strike me as a real problem.
turn that around, what's wrong with a rule that's going to have that massive an impact on the national economy, sort of waiting, kicking in until such time as the courts have declared it to be lawful?
Well, Dick would say what's wrong is you're missing the benefits that are an order of magnitude larger than the costs.
Right, I mean, that
In theory.
seems to me, it's not in theory, it's in fact. There's been loads of studies of that, and it's in fact. And I agree that the courts are imperfect in applying the four-part test. And I'd rather that this be resolved on the merits, but if we may be stuck with something else. And as much as I don't like saying, well, courts do the best you can with that four-part test, I don't have any better idea. And the idea of Congress across the board saying there's a stay on every major rule, I don't give a damn whether there's any serious legal questions or not. I don't give a damn whether there's big benefits and small costs. They're all Anything over $1 billion, which these days is small change, anything is automatically stayed. That's that's much worse than asking the courts to do the hard job of applying the 4-part test in each case and deciding whether to issue a stay.
John?
I wanted to raise some questions about the premise that a couple panelists have put forward, that one reason for increase of this phenomenon is congressional inactivity. So, for example, this summer, we got TSCA reform. The Republican Congress gave the EPA a massive expansion of its regulatory authority. Congress is capable of acting when it wants to. Flip side of that, if we look at, for example, the Bush administration EPA and its implementation of the Clean Air Act, the Bush EPA tried to very aggressively reinterpret the Clean Air Act and through regulations and through other actions. Why? Because the Bush administration was unwilling to cut the deal that Congress was willing to cut in terms of a 3 pollutant versus 4 pollutant reform of the Clean Air Act. It wasn't that Congress by itself was inactive. It was the executive branch didn't want to deal with Congress on Congress's terms, and so looked for other ways to advance its goals. And so I'm wondering just why we assume that it's congressional dysfunction as opposed to a more complicated dynamic, which would include executive branch not willing to accept legislation that isn't favorable enough to its position, and perhaps also a choice by some members in Congress that if they know the executive branch is going to try on their own, then members of Congress don't have to take a position. And just last point on that, one of my senators is notorious for simultaneously beating up on the EPA and saying how we need more regulations on greenhouse gases simultaneously. But he never wants to vote on that because he has coal miners in Southern Ohio and he has environmentalists in Northern Ohio. And what he wants is to be able to say what each wants to hear without ever having to take a position. And it seems that this phenomenon, if we think it's a response to that sort of thing by Congress, might actually be letting Congress off the hook, and that's another problem that we might want to be concerned about.
You want to address that? No?
Well, I agree with that in terms of so there you go. Kudos to Jonathan for that. I'd also say, though, that even if there were a problem, I think the next question is, what is it a problem from a constitutional standpoint? And is it something that, even if you get past that, agencies should be able to override that and basically say, well, we get to step into the gap and start acting like a Congress. I don't think that's remotely the way our government should proceed, and yet it seems like that's the way it has been proceeding.
Yeah, kind of what we have seen is Congress and others acknowledge that it's forfeited all this power and delegated all this power to agencies. And you've never heard in the political debate more this year about regulatory reform. It gets brought up now the way it never did before. It gets brought up now along with the debt and everything else. But Congress has delegated this power. What it has done is introduced a bunch of regulatory reform legislation like the RAINS Act and like the Scrub Act and some other things that don't have any chance of getting passage. But they haven't even taken the step of collecting vetoes on them. There's just not a lot of drive. That's why I was saying earlier that some of the easier things that help us catalog regulations better might be something more palatable in the short term that make longer term reforms possible. And I always stress the importance of trying to break off the existing regulatory state from the yet to come, the what's new.
I think also in relation to that, another interesting thing to catalog would be, if it's possible to find a connection between members of Congress and the exemptions and other kinds of guidance that are issued, because I think that is one way that members of Congress benefit, because they get to influence what the administrators are doing, particularly in the context of the things that they do less formally. Bill?
So you all have focused on the kind of image of the rapacious overregulator or the agency putting out guidance documents that shouldn't be issued. But I think a lot of businesses, at least when I was practicing, when you talk to people in business, their bigger concern is agencies that drag their feet, that don't get work done, that under-regulate, that don't address a risk, that actually will not assert themselves in a risky area for fear of years of work and later judicial rejection. I'm just curious if you flip the valence of your presumption that many agencies are not doing work that needs to be done, do do you think that there are best practices or ways the law should be reformed to address that problem, that is, to prompt agencies to act in a regulatory setting where it's needed?
That would take Congress to act.
Yeah, I mean, as you know, the legal doctrines try to force an agency to act even when there's a really clear mandate. I mean, that's, not just an uphill battle. It's like climbing up an ice sheet or something without any picks.
Dick years ago wrote a very good article in Hard Look Review, as have now a lot of people, but when you look at pages in the Federal Register, the reason why most people think that's an irrelevant piece of data is most agencies put lengthy statements in the Federal Register because they know they have to explain themselves, because when they do, even when they do act, they're going to be confronted with very vigorous review in the courts. And so for that reason, Hard Look Review itself could be a problem for those businesses. But you're certainly right that doctrine right now about challenging agencies is terrible. But I was just curious whether people on the CEI or Jeff, with your work with industry, when people are frustrated with inaction, do you think that there are best practices, or is there something like the Review Act that you're thinking of to try to prompt needed regulation?
Well, actually, in response to, in a sense, your first point, what I'd love to see is some judge or justice actually read the sentence in the Administrative Procedure Act that says that an agency is required to prepare a concise, general statement of basis and purpose, and that judicial decisions saying that the 1,736-page statement in this case does not adequately address the issues. That's really lawless. That's totally lawless, and that's come from the U.S. Supreme Court and every circuit court. That's lawless.
Well, it might be from the standpoint here, since the issue is ghost rules and other kinds of backdoor rulemaking. There is the 2007 OMB Good Guidance Practices memo in place. It wasn't completely gotten rid of by President Obama. It's still there. And in play with that now are several hundred pieces of guidance that agencies acknowledge. And part of the process would be paying more attention to that. A new executive, whichever president it is, can have a big influence on whether or not agencies look at guidance on any kind of a par, and I mean all kinds of guidances, but on any kind of par with ordinary rulemaking.
Yeah, and so quick thing, Bill. I'll fully admit from my standpoint that I have like a representativeness heuristic problem. I don't kind of call up agencies and say, hey, my client has a practical problem, can you help me work it out? So I just, I'm sure there are some instances like that, but so for me, what happens to me is, I get a call like, this is an incredibly expensive rulemaking that will, wreck X, Y, or Z segment of our industry. We need you to, take some kind of challenge forward. So that's kind of like what my, personal universe is like. So I probably overrepresent the kind of importance of that versus the kind of situation you're talking about, just given the nature of my practice. I would say in terms of the concise statement of basis and purpose that, look, I launch comments all the time. I might have 2 paragraphs and I get like a 12-paragraph response, but a lot of it can be mumbo jumbo and incantation, and they're not really grappling with the logical point that I'm making. And so you need judicial review to sort of compare logically what is being said and whether it's actually grappling with the comment. And inevitably that's going to add space to what a Federal Register says, but I don't think you can say, well, okay, here you have 1,000 words responding to a comment, ergo it's an illegitimate comment. I don't think that's lawless. I think that's inherently what a judge has to do in grappling with an argument that's put before it.
So I don't know if the panelists want to take a couple minutes each. We have about 5 or 6 minutes left to any other points you'd like to make?
You want to start being the authors and then?
How about we get to go last?
Yeah,
Okay.
that's great.
Okay, I'll just quickly say, I think this is an extremely important area of research, and there are going to be a lot of dissertations and master's degrees spun off of this notion of looking at agency sub-regulatory guidance and what the real effects are. And I think it's coming into play more in frontier sectors of the economy where you already have an ambitious agency already regulating the realm, like with FAA to regulate drones and the various kinds of regulation over highways and such. So I think as you do more case studies in the future and look, as we break this inventory out over the future, as you look at more, as we get more cost benefit or cost studies of guidance and determine its real significance compared to regulation, I think we're going to be surprised. Because I think in the future economy, it becomes less and less necessary to go through the normal rulemaking process when the guidance has become so sophisticated, and that's what concerns me now.
Sure. So again, yeah, I really like the paper. I think it obviously is, I think hopefully judged by the panel, kicks off really lively discussions of a lot of the problems in administrative law. I would say, just, because I haven't spent as much time on the state part as on some of the bigger administrative law questions, that, there's a case the Supreme Court decided called eBay, which was about applying the four-factor test to patents. And Professor Epstein was on the other side of that case from an amicus brief that I'd worked on. And basically the argument was, look, there are property rules and liability rules, like you remember the whole, Melamed kind of analysis, that if, because a patent is a property right, it must be protected by an automatic injunction. You don't use the four-factor test for that, was the argument. But, the Supreme Court, I think, came out the right place there, which is that, Congress had not acted specifically to override the traditional four-part balancing test of the chancellor, and therefore that four-part balancing test was left in place. And so actually that's one reason why I would say that in this kind of instance, Congress should be looking at more finely attuned remedies, right? Like maybe Professor Epstein was right as a matter of policy as to what the protective rights for patents should be. They shouldn't involve a four-factor balancing test. Maybe there should be something more like automatic stays, as I was, urging Congress is considering in that one particular piece of litigation. In legislation. I don't think you can say that an automatic stay is an idea that you should just immediately shoot down, because there's always the option, right? You can get immediate action. It's not like action is being postponed forever that will never occur through any other means if Congress were to adopt a statute doing what it is that the agencies want to do. And I would submit to you that if Congress doesn't do that, it's hard to posture delay as really being something that hurts people from a democratic and constitutional standpoint. And with that, I'd wrap.
Thanks. Dick, do you want to?
I just wanted to close with 2 points of agreement with my friend Wayne, and 1 point of disagreement. The point of agreement is we need a lot more study of this. We need a lot more data, whether that's done through think tanks or universities. I don't know. For instance, Lincoln's question is a great question. Just what do the other 99% of the guidance documents do? Somebody ought to take that on. Probably not a lazy, overpaid 73-year-old tenured professor, but there's some young people out there in need of tenure. And another point on which Wayne and I have agreed a number of times is we need a lot better staffing and funding of OABRA. That agency is really, really important, and at this point, it's barely surviving. It just doesn't have the resources it needs to accomplish its task. And then the one point on which I'm skeptical, the drone thing. As soon as somebody told me about drones and Amazon's going to use them for this, that, and the other, and aren't they wonderful? I said, isn't that wonderful? And then I started seeing, okay, this effort to fight this forest fire had to be stopped because some clown had put a drone up there so that some TV station could watch the fires. And that meant that you had to take all the planes out of the air because the drone might have, oh dear, that's really a problem I had. And then the one lands twice on the White House lawn, and I said, oh, well, wait a minute. And then the one that landed on the roof of the premier's house in Japan, and he said, wait a minute. These are hard questions. They're not easy questions. Yeah, there's tremendous potential for good from drones and tremendous potential for harm from drones. And no, FAA doesn't have that. Nobody has any of the answers, has all the answers at this point. Somebody's got to come up with them. I can't come up with a candidate better than FAA to try and struggle with them.
Just, can I say something quick on that? Just wait, my.
Okay, quick.
No, go ahead.
Yeah.
We'll take it up at the next debate.
Okay.
But I have an answer.
Okay, Lincoln, Amy, you
I'm
guys.
interested in the answer, and I have not much to say about drones, except I think it does, and I can't quite, bring to, bear the exact kind of power that Professor Pierce does. But I will say this, I think that drones and other examples of regulation bring up this idea that, there are, as Dick points out, some places where maybe guidance document has some value, others where they don't. I hope that one of the contributions we make in this paper is to identify a way to think about these different kinds of, as Wayne put it, sort of sub-regulatory action, where agencies really are trying to influence behavior, so that we can start cataloging them, so people can do case studies, so people can start doing analysis. And I hope that conceptualization begins that kind of quantification, because I think that quantification is important no matter what side of the debate you're on, of whether it's beneficial or not. And I think sometimes it will be beneficial and sometimes it won't. And I would also invite anybody, if you have examples that are particularly good, we're more than interested to hear about them. And then the second thing I would say is, I think we have to acknowledge at the outset that we, in trying to change the way that stays might get looked at by courts, we are fighting an uphill battle. The court in lots of cases, in Winter and the eBay case and others, has mentioned and sort of put an emphasis on this idea that the traditional four-part test is the kind of standard test. And so I think we acknowledge that up front, but that doesn't mean just because it's a traditional test, it's always going to be the right test. And I think there might be some circumstances where it's worth being modified, and I hope we might be able to make that contribution as well.
And I think where we think it's really important that we think about this is because of cases like Michigan v. EPA. I don't know that the administrative state can continue to have cases where there's an agency that celebrates at the end of it that everybody has already complied. It doesn't matter the validity of the rule. That threatens the administrative state altogether, and I think that's a really worthy exercise for us to think about.
Okay, well, thank you very much to our panelists, and that concludes our conference. Thank you all for coming.